Hi everyone, my name is Emily. You're at the EDC webinar. Thanks for being here. We're going to give it just a couple minutes to let everyone come in from the waiting room, so just know that you're in the right place and we're really glad to have you. So Brianne, let me know when we're ready to kick things off. And in the meantime, again, we're really happy that each of you is here. All right, I think we're going to get started. My name is Emily. You are at a webinar hosted by the Economic Development Collaborative of Ventura County, EDC. Thank you for joining us. I have a couple Zoom housekeeping notes. It's been a really long time since we've been in Zoom, so this may be redundant, so please just bear with me. Let's see. So this is set up as a webinar, so everyone is muted and there is no video. We are recording this webinar and you will get a copy of it in the follow-up email, as well as the PowerPoint that will be presented today. If you have any technical difficulties, please message the panelists using the chat box. If you have a question, post it to the Q&A feature. That can be found at the bottom of your screen. And if you accidentally post it in the chat, our team in the back end will redirect you to the Q&A. We have a whole bunch of people registered for this webinar, so we anticipate we're going to receive a lot of questions. So we ask that you wait until the end of the presentation to put your question in that Q&A box, because we may have answered it within the presentation. Our team on the back is also going to be watching those Q&As and filtering out duplicates. So just know that if you see your question disappear, that is the reason, and we will do our best to get to it. Let's see, we'll also do our best to answer some questions as we go along. So if you do ask a question, monitor that Q&A box, because we may answer your question using chat throughout the webinar. And then any questions that are left in the Q&A box, we will be doing live questions and answers at the end. So without further ado, thank you again for being here, EDC webinar, and I'm going to turn it over to my friend Doug.
Good afternoon. Welcome to our presentation, Creative Solutions for Commercial Landlords and Tenants During COVID-19. My name is Doug Bordner. I'm co-managing partner of Myers, Witters, Gibson, Jones, and Feingold. Our firm was founded in Ventura in 1971 and is one of the oldest law firms in Ventura County, as well as one of the largest. Our attorneys have expertise in a number of areas of law, including corporate, business, real estate, employment, personal injury, and estate planning. I'm here today with two of my colleagues from Myers Witters, my partner Mike Martin and our associate Rachel Coleman. Today's webinar presentation will be broken down into three areas. The first area will be covering commercial lease provisions, COVID-19 moratoriums and laws, and the effect of bankruptcies. In the second section, we will be talking about possible solutions for win-win solutions for landlords and tenants, and how to get to there. In our last section of the presentation, we'll be answering questions. And during the presentation, as Emily stated earlier, please post your questions to the Q&A bar at the bottom of your screen. And we're going to track the questions and then hopefully get to as many questions at the end of the presentation. And with that, let us begin.
Actually, I'm going to jump in really quick. Brianne, can you help us get into out of presenter mode? Brianne always loves when I make her talk during these things.
Yeah, so Jacqueline, you want to go back to the presenter mode instead of presentation mode without the notes, or I'll go ahead and share my screen.
Thanks, everyone. 2020 is so easy on all of us, isn't it? So we appreciate your patience and grace as we work out all these things. Brianne, you want to just go ahead and share your screen?
Yep, getting it pulled up right now.
Thank you so much.
Great.
All right, my friend Doug, take it
Okay,
away.
back to the webinar. So with the pandemic that we've had over the last 6 months, it's affected all commercial real estate across the board, whether it's restaurants, retail, office, personal services, entertainment, or construction. See, next slide. Okay, so the first thing to look at whenever you're in a pandemic where you have an economic downturn is to look at the terms of the lease. And there's generally a misconception. A lot of people think that you have what's called a standard commercial lease. And people rely on like the AR forms and different leases. But really there's no standard lease form, because with a lease, you always have different terms. Some terms are crossed out and some terms are added by addendums. But there's a couple of lease terms that you should be looking for whenever there's an economic downturn. The first is what's called a force majeure clause. And this is a clause which allows a party to either terminate or to suspend payment or performance. And the typical force majeure clause applies when there's, for instance, a terrorist act, government unrest, possibly strikes, and then also pandemics. Unfortunately, most leases don't have force majeure clauses, but some do. So that would be the first thing that both the landlord and the tenant should check in their leases. The second clause that you should be looking for if you're a tenant or a landlord is see if there is what's called a termination clause. A lot of leases have a clause which allows the tenant to terminate early by paying a fixed amount and maybe paying back some of the tenant improvements. So that's something both landlord and tenant should look and see if their leases have that. The third area which you should look at is a lot of leases have, when you enter into a lease, a lot of times the landlord provides tenant improvements, build outs of the space, whether it's a restaurant or office buildings. A lot of the leases have clauses which require the tenant to repay the landlord if they terminate the lease or the lease is terminated prior to the end of the term. So it's important to look at that, because if a tenant terminates a lease and they've got a clause like that, in addition to possibly owing rent, they could actually owe tens or hundreds of thousands of dollars for tenant improvements. So it's very important to look at that. The fourth area to look at in a lease before you do anything is see if there's personal guarantees. If you're a landlord, you want to know if you have additional parties who could be responsible for the rent. If you're the tenant and you've given a personal guarantee, this can make a big difference. If you have a corporation that signed the lease with no personal guarantees, then if it walked away, the judgment would be against the corporation. But if you have personal guarantees, you may be personally liable for the back rent, as well as possibly tenant improvement costs. And next slide. And with that, I'm going to pass it over to Rachel Coleman in my office, who's going to talk about the COVID-19 eviction moratorium laws.
Thanks, Doug. In response to the pandemic, many governments have enacted many confusing orders and ordinances for emergency tenant protections related to COVID-19. So when you're determining whether or not an eviction protection applies to your particular situation, we first have to look to the state, local, and federal tenant protections. Next slide. In California, we're going to look at the state moratoriums first. Governor Newsom issued 3 executive orders that provide commercial and residential tenants with relief from evictions due to non-payment of rent resulting from financial losses related to COVID-19. The orders ban landlords from filing unlawful detainer actions used to evict tenants for non-payment of rent. That lasts up until September of 2020. Next slide. There are some limitations to the moratoriums. They are not statewide moratorium eviction bans. The state moratorium lifts the state law restrictions that impede the ability of counties and cities to enact their own moratoriums. So you've seen that many cities and counties have their own. Moratoriums are also in flux, and they address the needs of landlords and tenants and also the strained court system. The court's having a lot of issues with backed up filings and filings that haven't been able to be processed. Many local governments also have not expanded moratoriums to include commercial tenancies. And we'll talk a little bit about that later. Next slide. Moratoriums are generally not blanket protection from eviction, but only apply if the tenant can demonstrate the inability to pay the rent due to financial impacts related to COVID-19. Some examples of that for commercial tenants are your employees were sick with COVID-19, you couldn't be open your regular hours, you had to reduce your hours or close hours of operation due to COVID-19. Maybe you had to reduce or actually close your business in order to comply with governmental recommendations and the various stay-at-home orders. Next slide. In order to qualify for relief under Governor Newsom's orders, tenants must notify their landlord in writing within 7 days after the rent's due to let the landlord know they've lost income resulting and the inability to pay all or some of the rent due to the financial impacts of COVID. Many county and city moratoriums have different deadlines under which you have to notify the landlord, so you'll have to watch out for those as well. Notice can be given to your landlord via email or text message, but the best practice is to review the lease and comply with the notice terms. All leases should have a clause in them that provides for where and how you give notice to your landlord. Another best practice is to also communicate with the landlord or the property manager before sending written notice. All you have to do is pick up the phone, and that really makes a big difference when you're trying to work out something with your landlord. In addition, the tenant has to show they're unable to pay the rent due to financial impacts of COVID. And those sort of things, you could have missed work because your child was needing care at school, and also maybe you've lost business customers or lost a lot of your business due to COVID-19. Next slide. In order to qualify for relief under the state moratorium, you have to also provide the landlord with documentation of your loss of income. And those types of things can be bank statements showing your pre and post COVID-19 deposits. You could also provide landlord with financial statements showing the income, profit, and loss sales pre and post COVID. You could provide spreadsheets for your business, general ledgers, income and expense journals. But also you want to make sure when you're providing this information to your landlord that you redact out, and what that means is you black out your bank account information. Next slide. Under the state moratorium, the tenant is still responsible for repayment of the unpaid rent. However, the executive orders do not give a specific time frame under which repayment has to be made to avoid eviction. It appears that most of the county and city moratoriums have repayment time frames, so that's another issue to look at when you're determining whether the tenant has to repay the rent to avoid eviction. So now we're going to go ahead and look at some of the local ordinances regarding eviction moratoriums. And because we only have a limited amount of time, we're only focusing on County of Ventura and City of Ventura for the purposes of this webinar. And I believe we're going to send a link out with all of the information after the webinar. So you can click a link and see pretty much all of the different moratoriums that may apply for your particular area. And just to clarify, the County of Ventura ordinance applies to the unincorporated areas of the county, while the City of Ventura ordinances apply to rental properties that are actually in the City of Ventura. Just wanted to point that out. So we're going to look at the Ventura County Ordinance 4563. It tracks the state moratoriums, but you have to be aware that there's different timelines for deadlines to notify your landlord, and also for repayment of the unpaid rent. To qualify under the Ventura County Ordinance, the tenants have to provide notice to the landlord within 30 days that the rent is due, that they aren't able to pay due to COVID-19. And they also have to provide documentation to the landlord of their income loss. Tenants are also encouraged to make partial payments of the rent to the extent it's possible. No timeline is actually given in the ordinance for repayment of the past rent. The moratorium for evictions will end on September 30th of 2020 for commercial tenants, as this ordinance tracks the executive orders from Governor Newsom. And what that means for commercial landlords is they can seek to evict commercial tenants for non-payment of the rent if that property is located in the unincorporated areas of Ventura County. Next slide. So now we're going to look at how you qualify for eviction relief under the Ventura City ordinances. Tenants must provide notice in writing to the landlord that they can't pay within 7 days after the rent's due, and also provide the loss of documentation within 30 days. In this ordinance, it actually states that tenants must pay the outstanding rent within 6 months of the expiration of the local emergency. Landlords also are prohibited from charging late fees on past due rent due to the financial impacts of COVID-19. And the moratorium lasts throughout the duration of the local emergency. Well, what does that mean? Well, what that means is that landlords should be aware that on September 8 of 2020, the Ventura City local emergency was extended through November 12 of 2020 by resolution 2020-044. And what that means is if you have commercial tenants within the city of Ventura, then the city moratoriums will still apply. However, if your rental property is in the unincorporated areas of this city, the local moratorium would not apply, allowing the landlord to pursue unlawful detainer actions after September 30th of 2020. So that's why it's really important to look at the different ordinances that'll apply to you to make sure you're following the law. So next we're going to discuss the Judicial Council moratorium rules. Next slide. The Judicial Council of California is the policy-making body of the California courts. On October 6th of 2020, the Judicial Council issued an emergency rule number 1. And what that rule did is it banned all the courts from issuing summonses on unlawful detainer actions based solely for non-payment of rent until September 30th of 2020. But on August 13, the Judicial Council lifted the freeze, allowing evictions as of September 1 of 2020. So what that means is it appears that where there's a local ordinance or a state ordinance banning eviction moratoriums, and if those are in effect, they can remain in place until the end of their term. So it doesn't mean that everyone can go ahead and start filing unlawful detainer actions. It just means if there's not a moratorium in place to protect the tenants, that it would be okay in that particular county for landlords to go ahead and file unlawful detainer actions. Next slide. So now we're going to discuss some relief for residential tenants. I know we had a lot of interest in covering that information as well. So we're going to look at federal eviction moratorium that was recently passed by the CDC. The CDC, Center for Disease Control, they issued a nationwide moratorium on evictions, which applies for September 4, 2020 and ends on December 31st of 2020. And that moratorium only applies to residential tenants and where the state or local government doesn't already have a similar moratorium in place. So if you live in an area where the state or the local entity hasn't issued a new moratorium, then you would be covered under the CDC guidelines. Also, on August 31st, Governor Newsom signed into state legislation the COVID-19 Tenant Relief Act of 2020. And this only protects residential tenants from evictions for non-payment of rent. And that ends on January 31st of 2021. And so under the Tenant Relief Act, landlords are banned from evicting residential tenants for non-payment of rent. However, landlords can evict tenants for reasons other than non-payment of rent, such as nuisance or lease violations, starting on October 5th. And again, the new moratorium only applies to residential tenants. Next slide. Under the Tenant Relief Act, landlords can serve a 15-day notice to quit or pay rent. That's a new twist because normally it's a 3-day notice. You have to serve that on your tenant by September 30th of 2020. The landlord must also give a notice that contains a warning from the state of California that the tenant has to provide a declaration to the landlord that the tenant cannot pay rent due to COVID-19. The landlord must also provide the tenant with what's called a declaration of COVID-19 related financial distress. So the tenant has to actually return that document to the landlord in order to qualify for protection. The tenant also has to tender payments to the landlord equal to but not less than 25% of each of the transitional rental payments demanded in one or more notices that may have been served on the tenant. So in addition to the declaration, the tenant has to actually have paid at least 25% of the rent in order for the landlord to go ahead and evict the tenant. Next slide. Another twist in the Tenant Relief Act only requires documentation of the loss of income for tenants that have an annual household income of 130% of the median income. That would be something that if you want to know if you qualify, you'd have to go to the Department of Housing and find out what the state income limits are. But just in general, proof of income is not required where a tenant makes less than $100,000 a year. So that's another twist in the new Tenant Relief Act. So next slide. So the bottom line for commercial tenants and landlords is that as the county moratorium ends on September 30th and the city moratorium ends on November 12th, commercial tenants and landlords must rely upon the moratoriums, and you're going to have to also rely upon negotiating with your landlord or the tenant to avoid evictions. So now I'm going to go ahead and turn it over to one of the other partners here at Myers-Witters, Michael Martin, and he's going to discuss the effects of bankruptcies on commercial tenancies.
Thank you, Rachel. That was good information. So the topic of bankruptcy is a huge one. It's a topic that we could dedicate, an entire day of a query into, but we're going to focus on a couple of key issues. And starting off, there are a couple of things that you should keep in mind. First of all, with bankruptcies, typically there's a clause in leases and commercial lease agreements where a lease will be terminated if the tenant files for bankruptcy. And you should be aware that typically these clauses are unenforceable and they will not be enforced in that case. The second thing is it's all about timing with bankruptcy, because when a bankruptcy is filed, an automatic stay is imposed with any creditors. What that means is it basically gives the debtor or the tenant time. It gives them a breathing spell away from creditors so that they can either liquidate their business or they can reorganize. It also tells creditors that they have to keep their hands off. They can't pursue any obligations for back rent or other creditors that might have obligations owing until they seek permission from the court. So it's basically a hands-off period. Okay, next slide. So the first thing with respect to timing is to consider if the bankruptcy was filed before a judgment for unlawful detainer is obtained. Basically, what you should know, if the bankruptcy is filed before the judgment is obtained, then a landlord cannot terminate or evict the tenant during that time. Instead, a landlord is required to go to federal court and ask the judge to lift the stay, and so they can continue the ongoing action. In other words, so they can continue their unlawful detainer proceeding, so they can continue their lawsuit, continue collection efforts. Generally, a landlord cannot even enforce a judgment. So even though a landlord may have a judgment already, if that stay is imposed, if a bankruptcy is filed, the landlord cannot even enforce a judgment that it has for back rent without applying to the court for some relief from the stay, which means the stay doesn't apply to me, landlord. I can proceed against the tenant or against this obligation, even though there's a bankruptcy in place. So you have to get the permission from the bankruptcy court. Okay, next slide. So the way to do that, the way to get the court's permission is to bring what's called a motion for relief from the automatic stay. The motion for relief from stay should be considered if the landlord, as I mentioned before, isn't receiving those post-petition rent payments. So what that means, the landlord isn't receiving money that became due or rent that became due after the tenant filed for bankruptcy. Also, for situations where the lease term has not expired or a tenancy is a month-to-month situation. So the lease is continuing on. The landlord wants a determination as to what it should do to enforce that lease obligation. Also, the landlord should consider, is it willing to risk having a vacancy? So if the landlord files for relief from the stay, that means it's going to proceed against the tenant to regain possession, which means it'll be out of a tenant. The tenant will be gone, the property will most likely be vacated, and then the landlord's going to have to find a new tenant. So the landlord has to understand, are you willing to risk having a vacancy if you're successful? And finally, if the trustee, that's in a Chapter 7, a liquidation, a trustee is put in control in a Chapter 7 matter, or the tenant, if the tenant doesn't provide adequate assurance, in other words, it doesn't have the resources to continue paying the lease obligations, or it's not going to provide for someone or either assume the lease. So in those motions for release from automatic stay, one thing to always include, and your bankruptcy attorney will most likely do this, make sure that it includes an order that the possession of the property be restored to the landlord. In other words, the landlord wants possession back of the tenancy, so that you want to make sure that's included in the order for your motion, on your motion. You're going to ask the court to give you that right. And also that you would be permitted to continue with your unlawful detainer action or your eviction action, or that you would be able to start an eviction action if that's what you want to do against the tenant that's not paying rent. So next slide. And so alternative to a motion for relief from automatic stay is in a situation, even if you lose on your motion for relief from stay, or if things are not proceeding quickly enough, the landlord can always bring what's called a motion to compel. Typically, it will do this if there's value in the lease. So if there's a considerable term on the lease left on it, if there's a lot of money at issue, that money can go to paying creditors. Then a lot of times, sometimes the court will be disinclined to grant that motion for relief from stay. But what a motion to compel does is it basically puts pressure on the parties to force the issue. And so a landlord may consider bringing a motion to compel the trustee in possession to either assume or reject the lease within a certain period of time, or at least provide adequate protection that it will be able to make those post-petition payments. Okay, next slide. So next issue. So if a bankruptcy is filed, we've talked about before. Now, if a bankruptcy is filed after a judgment is obtained, then generally the stay doesn't apply. And a landlord can proceed immediately without going to court to ask for permission. However, a tenant cannot stop the eviction except in a few circumstances, and that's only if within 30 days after the petition or after the bankruptcy has been filed, that the tenant certifies that it can cure the monetary default and it deposits the money with the court. So one thing to keep in mind for landlords, if there's an eviction that's scheduled, you have a judgment prior to the entry of the bankruptcy, and the tenant does not take action to alleviate the stay, then the landlord should take action, including notifying the sheriff or the proper authority that it wants to continue with the eviction. All right, next slide. So when there's doubt as to whether or not a stay applies, this hands-off period, and if a lease, in such situations, if the lease has been terminated before the expiration of the tenancy, so there's been an issue, there's been a default, and the landlord has elected to terminate the lease agreement, then a bankruptcy is filed. The landlord should still go to court to get the court's stamp of approval that it can proceed with an unlawful detainer action in such cases. And in any event, if there's ever doubt, the landlord or the creditor can file a motion with the court confirming whether or not the stay applies in this situation. Next is just a general issue. In such situations, if a judgment is obtained before the bankruptcy, landlords cannot use the security deposit to offset past rent. Such use of a security deposit after bankruptcy has been filed could subject the landlord to liability, and that includes actual and punitive damages. So it's important to remember a stay is a serious thing. You want the court's approval if you can get it. All right, next slide. So if things stall out during bankruptcy, this is just good to know that there are timelines built within the bankruptcy process that are going to kind of flow or should flow automatically. So if a tenant doesn't move or the landlord loses its motion for relief from stay, then the lease will be deemed rejected automatically unless the tenant or the trustee assumes the lease within a specified period of time. So generally in Chapter 7 cases, that's liquidation, where the tenant is liquidating their assets, they're going out of business, then it's going to be within 120 days. And then otherwise, it's going to be any time before there's been a confirmation of a reorganization plan, and that would be in Chapters 11, 12, and 13 reorganization bankruptcies. Typically, though, it's going to be a business judgment decision on the part of the landlord. I mean, on the part of the court. It's going to make a determination as to what kind of value, as I mentioned before, what kind of value does that lease have, and will continuing the lease benefit creditors ultimately. So the court's going to make this determination. Okay, next slide. So if the bankruptcy court makes a determination that there's going to be an assumption of that lease, that means an assumption of the lease by a third party, a new party to the lease. And you should know, landlords, that a trustee in a Chapter 7 case can always assign a lease to a third party, even if the lease has a provision in it that prohibits such assignments. It's part of the bankruptcy process. And even so, tenants generally are required to pay back all the rent damages caused by any default and must give adequate assurances that they're able to comply in the future. All right, and that concludes our overview of bankruptcy issues. So I want to turn things over to Doug to talk about win-win situations.
Thank you, Mike. We're going to start off with, before we get into the win-win situations, we're going to look at some general principles. And the first principle is basically that a landlord cannot resort to self-help. So what is self-help? I'll give you a couple examples that I've seen in the last couple of months. Self-help is when a landlord, for instance, goes in and changes the locks on the office, or goes into a warehouse and changes the locks, notifies security. I had one client who was behind in rent, and the landlord notified the security company that they could not access the property and changed the access codes. Another one, the self-help is actually removing a tenant's property from their building or office. Self-help is just, it's not allowed. Basically, when a landlord has a tenant, the tenant is not a trespasser, but actually a tenant has a right to occupy the space and have peaceful and quiet enjoyment until such time as a judgment is actually rendered by a court evicting them. So for the landlords, if they actually engage in self-help, such as locking a tenant out, removing a tenant's furniture, equipment, assets, they can be subject to significant penalties and damages. So landlords really must choose between negotiating or litigating. And so before we get into all the looking for win-win solutions, I'm going to have Mike Martin talk about choosing between negotiating and litigating. Mike?
Okay. Well, I think Doug, these are, you're going to talk about these. If you're negotiating with your tenant.
Actually, yeah, let me go through these. If you're going to negotiate with your tenant, you need to check out a couple things. First of all, you need to look at the tenant's long-term and short-term financial situation. Are they struggling financially because of COVID? Were they struggling before COVID? Does it look like they're, from the bank statements, credit reports, profit loss statements, that they're going to be able to make it? And you also got to look at, how strong their credit is. The second thing you need to figure out is you need to look at your goal. As a landlord, do you want to retain a struggling tenant? Do you want to ask the tenant for something in exchange for giving them some concessions? What do you want? Do you want to negotiate possibly amending or revising the lease, doing a lease modification? Should you attempt to replace the tenant? And what is the rate a new tenant you'd be able to get for a new tenant? It's also important to look at, not only the cost of replacing a tenant, for instance, paying a realtor for a commission to find a new tenant, but also looking at how long it will take a tenant to find a new tenant. There's a lot of times where if it's like large industrial space or large office space, like a whole floor, which I've seen, it can take over a year or even 2 years to lease it. So that's time you're not going to be getting any rent. Next slide. So now we'll go to the general principle number 2, which is consider pros and cons of litigation. So I'll pass it again to Mike.
Okay, thank you, Doug. So pros and cons of litigation. One thing that we need to consider is what is an unlawful detainer lawsuit or an eviction lawsuit. It's something we should touch on at least in this forum. So first of all, you should know that it's an expedited court procedure that allows a landlord to regain possession. That's really the ultimate goal of an unlawful detainer lawsuit, is that the landlord be entitled to receive possession. Also, it includes within that the right to recoup any back rent. And it's expedited in that typically from the moment, the time you file the case until there's going to be a trial on the case can take about a month. So the typical case can take a year and a half to 2 years before there's a resolution. But with unlawful detainers, it can be done in as quick as a month and a half. So the expedited nature of unlawful detainer, basically it's beneficial because it does force the parties to work together. It forces the tenant to act quickly, the parties not to sit on their rights or not to make a decision. And you should know that during the process, even though you filed an unlawful detainer action, it doesn't prohibit the parties from continuing to talk. In fact, it can encourage settlement negotiation because it puts pressure, because there's going to be a trial coming up. If the parties don't work out a resolution, then they're going to have to go to trial, present evidence, and leave it to the discretion of the court to make a decision. So the procedure really should be a matter of routine, but it should be understood that unlawful detainer lawsuits can be powerful remedies. I had a commercial unlawful detainer a couple years back that involved my client was the landlord for a large a large shopping center space and in a big box store area, and one of the tenants was a jewelry store. And so we obtained a judgment against the jewelry store, and then we had a writ of possession that allowed us to go into the jewelry store and actually take the jewelry out of the jewelry store and use that for payment of the rent. So a lot of times people don't want to have to go through the process of what an unlawful detainer judgment can mean for the parties. And it's good to consider trying to find a resolution. So next slide. You should consider the pros and cons of litigation. Obviously, there are advantages. It ends negotiations and it stops the stall tactics between the parties. It gives negotiation leverage, and it starts the clock on the eviction, as we've already discussed. However, there are disadvantages. There is time and money. Now, I just mentioned that it's an expedited process, but it still takes time, especially in the COVID world. We don't know what the courts are doing. We don't know how backlogged they are. In reality, we don't know how long it's actually going to take to run some of these unlawful detainers and commercial unlawful detainers through the court system because things are so incredibly backlogged. So that's something to consider. Also, it's stressful. Litigation is always stressful, and it can destroy a relationship. Even though your tenant is having a difficult time paying, that tenant it could be a valuable tenant that you want to, in a relationship that you want to preserve for the future. So that has to be taken into consideration because litigation often destroys those relationships, unfortunately. And then trying to find another tenant during post-COVID times could prove to be very difficult in the future. All right, next slide. General principle number 3, be proactive. Landlords generally should know that they need to step up, enforce their rights under the lease agreement, because if you try to sit back too long, if you try to not assert your rights under the lease or the obligations of the tenant under the lease, then those actions could constitute or deemed by the court to be a waiver of some of the provisions in your lease agreement. So the failure of a landlord to enforce its rights under the agreement can send also a dangerous message to the tenant that you're going to be lenient. For tenants, from their perspective, it's a good idea to keep those lines of communication open. Silence, as we've been saying throughout this presentation, is typically not a good option. It's always good to keep the lines open and to act early to try to prevent a worsening of the relationship, and not stick your head in the proverbial sand, but to communicate the best you can with your landlord on both parties. The goal is ultimately to mitigate against damages. Tenants and landlords both should look at this as an effort to keep their damages down. Okay, next slide, please. So if the parties do come up with a deal, they've worked out some concessions, they've come up with an agreement, I'd recommend that agreement be done so confidentially, because a landlord may have a lot of tenants, and this could be a special relationship that it wants to preserve. It needs to keep that special relationship in kid gloves, that it needs to be taken care of and preserved, because any information about those agreements that you've worked out with a tenant or the parties have worked out together could get back to other parties, other tenants, and it could compromise any deal that you have with other tenants. So generally, it's a good principle to wrap up any agreements that you have into the context of confidentiality. All right, next principle, number 5. Finally, this is kind of a common sense slide. Remember, there are always two sides to the negotiating process. Both sides have a lot of leverage. If the landlord is willing to make concessions, then obviously from the other side, the tenant should be willing to relinquish some of its rights under the lease in order to get the job done. Ultimately, you want to preserve, if that's what you want to do, preserve the tenancy and move forward beyond this COVID. That's what the parties should consider. All right, and that concludes this portion. I'm going to turn it over to Rachel for solution number 1 on postponing and restructuring the rent.
Rachel, we're going to ask you to unmute yourself, pretty please.
Oh,
Thank you, ma'am.
is it working now?
Yes, it is. Thank you.
Okay, excellent. So solution number 1 about postponing or restructuring the rent. There's actually 2 options to this. Option number 1 is a landlord can consider giving the tenant a temporary period of free rent other than reduced rent. For example, instead of paying your rent from September to December, the tenant could request that the landlord increase the rental payments the following year by a certain dollar amount in order for the landlord to recover the temporary period of free rent. So what does that mean? Well, I recently assisted a nail salon owner who had been closed for the last 5 months due to COVID, and she was just not able to pay the rent. We were able to negotiate with her landlord to allow her to have a free rental period for the months of June to October of this year. So in exchange, what we did was we we added remaining portions of her rent to her rental payments for the month of January to August of next year. So that way the client, she was able to keep operating her business. The landlord was able to keep the tenant and the rental income. The landlord was able to avoid litigating and spending all that time and money. And this type of arrangement's appearing to work pretty well for those in the personal services, hospitality, and restaurant sectors. Option number 2 is the landlord can recover the lost rent by extending the length of the lease. For example, in exchange for a free period of rent, the landlord could add additional months or years onto the length of the lease to make up for the lost rent. So if you had a 3-year lease and you're on year number 2, maybe the landlord could extend your lease to make it a 4-year lease in order to make up for the reduced or free rent period. This also seems to be a good option for those personal services, hospitality, restaurant sectors, and business sectors. And then if you want to go to the next slide, we're going to look at another solution, number 2, which is called cash for keys. And there's actually 2 different options there as well. The first one is the landlord can consider taking a lump sum payment from the tenant in exchange for the tenant surrendering the premises and terminating the lease agreement early. So in exchange for that, the landlord would agree to release any and all claims against the tenant for breaching the lease agreement early. For example, if you had 2 years left on the lease, the parties could come up to some kind of an agreement for a lump sum discounted payment, and that way the landlord could avoid resorting to the legal process to evict the tenant. And also it's, as you may know, it's very difficult sometimes to collect on judgments to get amounts owing. So we were able to work this arrangement out for one of our clients to avoid the cost of the landlord litigating with the tenant. And on a good note, the landlord was actually able to find a new renter for that commercial space. Option number 2, this often works in residential tenancies. The landlord can also pay the tenant a lump sum that requires the tenant to forego all notice requirements and voluntarily vacate the property, release any and all claims against the landlord in exchange for giving the landlord back possession of the property. In this option, the landlord may also consider offering the tenant to pay for their moving services as part of the agreement. So the tenant will vacate the property without a need for litigation. And oftentimes if you sit and you figure out how much would it cost to hire a lawyer and go through the process, it might be better off to offer paying the tenant a lump sum or giving them some money to move in order to avoid a litigation. So now I'm going to turn it back over to Doug, and he's going to discuss some other win-win solutions.
Thank you, Rachel. So the next one we're going to talk about is getting additional cash security. That's another possible solution. Now, there's a couple ways you can do that. If you're a landlord, you could require a tenant to give you what's called a letter of credit. You could increase the security deposit, or you could have the tenant give you a bond. Back in this was end of '99 when the dot-com bust happened, I had a number of clients who were tenants in downtown office buildings. And one of the ways they dealt with the downturn during that economic crash was they actually did a letter of credit. So that's a good way of doing it. And basically they default and that the letter of credit covered it. Another option for a landlord is, if they can't post the security, is consider getting additional guarantees. This could be, other investors in the company that's the tenant, or it could be parents or brothers of the tenant. There's different options, but it's a good idea to look at, see what other additional guarantees you can get, because that gives you, the landlord, more options if the tenant does default on the rent. Next slide. So the solution 4 is see if you can get additional collateral. By that we mean see if you can get, for instance, a UCC1, for instance, in their furniture, fixtures, the tenant's intellectual property, possibly even liens in their UCC1 lien against their bank accounts. their accounts receivable. And the nice thing about that is if you get a recorded lien, then you're in a higher position if they do file bankruptcy as well down the road. But the most important thing is to be creative and look outside of the box and see if you guys can come up with a solution that will work for everybody. Next slide. Solution 5 is in-kind services in lieu of rent. And this one I've seen done quite a bit in both the service industry mostly. But for instance, if you have a tenant who's a printing business, then maybe if you need printing, do trade for services, in-kind services for the rent, or IT support, or website design, or even legal services or accounting services. Restaurants, I've seen restaurants do the same thing, in-kind services or graphic design. I've also seen restaurants have their lease changed where they pay a percentage of what their monthly gross income is rather than paying a fixed dollar amount for rent. Next slide. Solution 6 is maybe if you've got a tenant that owes you a lot of rent, see if you can get a promissory note for the rent and maybe secure the promissory note by either a residence or a personal guarantee from some other individual. If it's unsecured, it's risky for the landlord. If it's secured by somebody's house or property, then that is a very good chance you'll get paid because they don't want you to foreclose on it. If you did have to foreclose, hopefully that property has some equity and you can get your rent out of it. Next slide. Solution 7. I've actually seen this one used quite a bit in the last recession. And that is actually giving the landlord an interest in your company. I remember I guess it was about 1993, we had a client who was struggling and couldn't pay rent. And they actually worked a deal with the landlord that they gave him shares of stock in their company in exchange for forgiveness of the past due rent. And then they had a clause that they would buy it back from a certain point. So that's one option. See if the landlord would be interested in getting some stock in your company or membership interest if you have an LLC in exchange for rent. Just be clear on the sale back to the tenant of the shares or the membership interest. Have an agreement in place that specifies when the tenant can buy it back and preferably even what price they can buy it back. Next slide. Solution 8 is one that I saw a lot in the last recession. And that was, if a landlord has smaller space that the tenant can use and they'd be able to afford is see if you can move the tenant to a smaller space where the rent is less, and then it would also freeze up the larger space for you to rent it out. Now the key on that is, you want to make sure it's a good tenant that you want to keep. If it's a tenant that's been a problem for a number of years, you may not want to do that. But this is a good way too, is reduce the space. That makes the landlord is happy they still have a tenant, and the tenant's happy because they've still got an office. Next slide. So solution 9 is third-party sources of relief. And this is important for both landlord and tenant to look at. For a landlord, because the landlord, when they have tenants that aren't paying their rent, if they have a loan, they still have to pay their loan payments. And so the landlord often is worried about losing the building that they have. And so they need to look at, from their side, they need to see if they can possibly get a forbearance or they can get a modification of their loan. Another thing that both the landlord and the tenant should look at is see if they have business interruption insurance. In some cases, we found it covers pandemics and this type of situation. A lot of times we found it doesn't, but it's worth looking in to see if you have it and see if it might cover your loss of income. Another one is emergency and disaster relief loans. For instance, the SBA, in EDC and local governments and Chamber of Commerce's often have some emergency relief loans or grants that businesses can apply for. And it's both, I'm seeing both landlords and tenants applying for the grants and for the different loans. Another thing is if you're the tenant or the landlord, see if you can reduce your other expenses. For instance, I've heard that Southern California Edison, Verizon, And some internet companies are working with companies that have been affected by COVID. So it's important to look at all angles to see it, because that can save the tenant money that they can put toward rent, for instance. Next slide. I'm going to pass this over to Mike Martin.
All right, thank you, Doug. So after you come to terms, whatever the deal is that you work out, the parties work out with each other, the tenant and the landlord, as I mentioned before, it's a good idea to memorialize those terms, memorialize the deal in some sort of a confidential amendment to the lease. Keep it between the parties. It can be your particular arrangement that you have with each other. The other thing that is kind of an interesting tool is if you are a landlord and you have an unlawful detainer, an eviction action that's going, and then you work out a deal with your tenant, you've both come up with a solution, you can actually put those deal terms into what's called a stipulation for entry of judgment. And you can notify the court and say, here are all the deal terms. The tenant has signed off on them. The landlord has signed off on them. And this way, if the tenant defaults, then the landlord doesn't have to go back to court. The judgment has already been entered. It just has to show the court that there's been a breach of the terms, prove that up, and then the court can go ahead and enter the judgment for repossession of the property and for recovery of damages if a certain sum has not been paid. I've had this happen on several occasions where the parties have come together recently, in fact, where the parties come together, they work out the terms. In the most recent case, the tenant was unable to fulfill its obligations that they had worked out with the landlord. And we just went right back to court. It was an expedited process. And the judge entered a judgment for eviction, and the landlord regained possession of the property and any payments that had not already been made. So lastly, the landlord can always agree that any concessions it makes as part of the terms of the agreement, any concession that it makes could be withdrawn in the future if the tenant defaults. So it's all predicated on the belief that the tenant is going to be able to fulfill their obligations. Okay, finally, last slide. If negotiations fall apart, remember, we've already talked about this, but litigation is expensive, it's time consuming. Keep that in mind. And there is another option that you have to consider, and that's something called alternative dispute resolution. And typically that's a situation where you go into mediation. You have a neutral third party. Oftentimes it's a judge or an experienced attorney in unlawful detainers or commercial lease matters. And that person helps the parties work out a deal. They usually put the parties in different rooms, and they go back and forth between the parties to find out if there's a resolution. And 98 or thereabouts percentage of cases end up resolving or settling themselves before they ever get to trial. So that is an indication that there's always hope that you can settle things before having to resort to litigation. For a couple $1,000, it might save the relationship and allow you to continue. So that's going to be the last slide, and I want to open it up to questions. Thank you so much, everybody, for attending.
Hi, thank you guys so much. This was really good, and thank you for the question. I'm sorry, I just got distracted. Thank you for the questions in the Q&A. For a few of you, I was following the presentation and I typed notes like, I think we just answered your question. So if I made a mistake or you need more clarification, just please repost that in the Q&A. So the first question is, when the housing authority pays 2/3 rent to the landlord the first of each month, does this cover and satisfy the tenant's 25%?
Rachel, do you want to respond to this one? You're on mute. Still on mute.
Oh no, there she goes.
There she goes.
Okay. Unfortunately, I don't really know the exact answer to your question because I haven't really dealt with any housing authority cases. But if you actually go to the code section, hold on, I'm trying to find where it is. In the slide, it has the particular code section that refers to the 25% payments. But it sounds to me like in your situation, if the housing authority is paying basically 75% of your rent, that should probably more than cover the 25%. But if you have questions about that, I would actually contact the housing authority directly and ask them if they would be covered. And that's civil code section. It's actually civil procedure code section 1179.03 2B. And just ask the housing authority if they're making the payments, if that's going to cover you from being evicted under the new Tenant Relief Act.
Would you read that number one more time? And Cecily, could you type it into the chat just in case our questioner missed all of those numbers?
Yeah, sure. It's CCP section 1179.03, parent 2, parent uppercase B.
Thank
And
you.
that's in the new Tenant Relief Act, and it's also in one of our slides.
Great, thank you.
You're
Next
welcome.
question. When is the right time to negotiate our lease? I don't know how long business will be slow, and to survive, I need rent deferral now and maybe rent forgiveness and possibly rent reduction if business does not come back. How many times will landlords, and in my case, the city of Santa Barbara, come to the table?
Mike, do you want to answer that?
Yeah, sure. I think any time is a good time to begin negotiating your lease. If you're having issues or you foresee those issues in the future, they're just around the corner, I think that this is a good time right now to reach out and relay some of those. As far as the city of Santa Barbara coming to the table, I'm not sure that the city is actually going to do anything proactively. Instead, the ordinances that they enact basically are, on the books, and it's up for the courts whether or not they're going to, enforce them. But long story short, I think that it's always a good idea right now, if you foresee having issues, to go ahead and bring those up with your landlord.
Great, thank you. Is there anything on the table with the state to extend commercial leases rent deferrals beyond September 30th?
I can actually answer that. I had breakfast with an assembly person a couple weeks ago, and there's nothing on the table for commercial leases as far as extending moratoriums or rent deferrals.
Great, thank you. What are the actual rights under deferrals in Thousand Oaks for the September deferral?
Mike, do you want to answer that, or you want me to?
If you've got it, we have to look up that particular jurisdiction.
So we could, why
Let
don't
me
we
go
go back to this? Yeah.
Actually, yeah, I just wanted to point out that I had mentioned it earlier, but EDC, when they send around the PowerPoint slides, they're actually going to give you all a link that links to pretty much all the moratoriums within the counties and cities of California. So you'll be able to click on that link, and then you'll be able to go to the particular ordinance for your particular city or county. So that might be a good way for us, if other people have questions with regards to their particular area, that they can go ahead and look to that. So you will get that link.
Wonderful, thank you so much. So this is a great one. How do we contact your firm? So I think we'll put your contact information in the follow-up email. So anyone who is in attendance today will get that contact information along with the PowerPoint and that link that Rachel was just talking about, and a link to this recording.
Emily, do you have that question for Thousand Oaks again?
Yes, hold on, I gotta go find it. What are the actual rights under deferrals in Thousand Oaks for the September deferral?
Okay, for Thousand Oaks, it basically is coming up on September 30th, the same as everybody else. and you're supposed to do documentation, provide within 30 days after rent is due documentation, and notify your landlord that you can't pay it. But they also have the tenant must repay the back rent within 6 months after the emergency order is lifted. So they've got 6 months for commercial, they have 6 months to pay back the back rent.
Mhm. Great, thank you. And this is sort of a follow-up on that. And anonymous attendee, I think a lot of people are going to resonate with your challenges. We are commercial tenants. Our business has been closed for 6 months by government order. So far, the landlord relationship is friendly with us, providing regular updates. They're offering only the 6-month delay per the law on the back rent. How should we approach asking them about their interpretation of the force majeure clause, which we do have? Next step in negotiation. We plan to stay in business, but paying 6 months of back rent is challenging.
Mike, do you want to answer that?
Well, we just need to look at the force majeure clause. I mean, what does the force majeure clause in your lease say? Does it say that that it will constitute it will be an opportunity that you can get out of the lease? If that's the case, then the force, it could be that you can use that as leverage to point back to your landlord to say, you have the right to actually terminate the lease if that's what the force majeure clause says. Or the force majeure clause may say that in pandemics or in situations like this, that other conditions apply or other issues apply. So it just kind of depends on what the provision says.
Great, thank you. I got an increase in rent during COVID. Is this a thing? I did too, so I can tell you, yes, it is a thing. Do any of you guys have more input on that?
It depends if it's commercial or residential. I didn't see anything that prevented people from raising the rents, unfortunately. Rachel, you can chime in if you've seen anything like that.
No, I haven't really seen anything with regards to limitations on increasing of rent.
I do know that if it's residential, there was a law that was passed in, I believe, December this last year, went into effect this year, that restricts how much they can raise the residential rent basically in a 12-month period.
Well, and one thing, just anecdotally, especially in the city of Ventura, so many of the landlords own most of the property. And so that is a challenge specifically in the city of Ventura that, they really are able to control that market because they own most of it. So free anecdote, worth what you paid for it. Can you just negotiate a stipulated judgment, or do you still need to file an unlawful detainer?
Mike, would you like to answer that?
Typically, a stipulated judgment only comes into play when an unlawful detainer lawsuit has been filed. So what the unlawful detainer judgment or unlawful detainer action does is it opens up the process and it gives the court jurisdiction for its ability to enter a stipulated judgment, because the parties have to agree that the court, because typically what happens is when an unlawful detainer judgment is entered, then the court kind of relinquishes its jurisdiction over the parties and over the case. But what the parties have to do going into, if they're in the middle of litigation, is that they have to agree that the court will retain jurisdiction over them in the event that there's a default, and that the court has the power and authority to enter a judgment even after the case basically is finished. So there is a mechanism called a stipulated judgment, or there's also something called a confession of judgment, and that takes a little bit more groundwork. But the answer is, typically for a stipulation for judgment, you've got to have an open case. But you may, if the parties are already willing to stipulate to a judgment, then there may be a vehicle called a confession of judgment that would do basically the same thing, where the parties could agree on the terms, they could file the paperwork, and then that confession of judgment would come into play to basically have the same effect if there's a default.
Great. So that was actually a follow-up statement. And so if the tenant has vacated the space and turned the keys over to you, do you have to file an unlawful detainer to ensure you have judgment on rent still owed? So does that adjust your answer at all?
Yeah, so then it becomes just a regular civil case for breach of contract, because under the lease agreement, you're getting two things. You're getting an obligation to pay rent, but you also have the obligation to provide possession to the tenant. So an unlawful detainer really is all about giving the landlord possession of the property again. So once possession has been restored, the unlawful detainer judge kind of loses its authority over the case, and the case kind of becomes a common breach of contract case where you're just trying to recover the back rent. And so it usually switches out, it goes on another track. It switches out of the unlawful detainer courtroom track, and it goes into the regular civil courtroom track, which can be a more long and drawn out process, but it becomes just basically a breach of contract case.
Great, thank you. My landlord has removed a few amenities that brought value to where we live, such as a table in our community area. She wants to rent out the common area for parking, but all of the tenants want to have our table back. Our property manager has only told us they are revisiting parking alternatives, but not told us about the new plan or that the table would be removed. Does this break the contract, or who can we talk to about these actions?
You would actually need to check out the lease and have the lease reviewed to see what the lease actually provides for and what you get as a tenant.
Great, thank you. Is the emergency order the same as the eviction moratorium?
Mike, or actually Rachel, you want to handle this?
Yeah, no, they're two different things. So the emergency eviction moratoriums, those are usually done through the ordinances of each city and the county. The governor did issue 3 executive orders, and that's different from the current Tenant Relief Act. So they're two different things. Are you a residential tenant, or is this a commercial tenant?
Anonymous attendee, chat that to us in the chat, and we can come back to the answer if it's nuanced. Waiting for anonymous attendee. Okay, we'll come back to this. What are your views on how to mitigate the impending national eviction crisis when government moratoriums are listed? Who is ultimately going to foot the bill, and can privately funded organizations like the Resident Relief Foundation help?
Mike, do you have a view?
I don't. That's a good question. That's a policy question. How about you, Doug?
Well, I can tell you, it's a big concern of mine, both residential and commercial, because of, what it was going to happen when the moratoriums do get lifted. Is there going to be a lot of people evicted, both residentially and commercial? And, unfortunately, I think, all of the citizens here and people who are going to be affected by it, because economically it's going to affect everybody. Rachel, do you have a view?
Pretty much what you said. I'm very concerned. I mean, based on the calls that we're getting, it seems like, this is going to affect a lot of people across, the entire nation. And there's going to be a lot of, empty commercial spaces possibly. And the courts are probably going to be flooded with unlawful detainer actions. And who knows how long that's going to take to get through the system. So, I mean, there's really no, clear answer on that.
Thank you. For commercial properties, is there a payback time frame depending on the number of employees a tenant has?
I can answer that. In Ventura, Oxnard, Camarillo, there isn't. But in I believe LA County, there is some provision that it depends on the time frame for paying it back is shorter if you're a larger business and longer if you're a smaller business. So it all depends on the city and county. So you have to really look at, where you're located and see what they specifically provide.
Great, and we've got one question left. So all of you who are still with us, if you have any more follow-up questions, please put them in the Q&A. Oh, thanks, Jonathan. We just got another one. Commercial tenancy. When does the emergency order end for rent repayment to be started?
What is it, Ventura County?
Karen, let us know what county you're in the chat.
Rachel, let's assume Ventura County. What would the answer?
Oh, Los Angeles.
Los Angeles.
Hold on, let me see if I can look it up real quick.
All right, while you're looking it up, so Karen will come back. Oh, Karen also wants to know Ventura though. So our business informed the landlord we needed to defer September rent. Our commercial landlord threatened immediate eviction if we elected to defer September rent. There was no clarification from Thousand Oaks town manager first week of September. We made a rent payment as we informed the landlord and put on the check October 2020 prepaid rent and told the landlord that we reserved all rights to make a rent payment. They have been informed we are taking deferral. We did not waive rights. How can we proceed?
Mike, do you want to handle that one?
Yeah, that's a good question. I mean, just generally speaking, it's hard to know the specifics. But generally speaking, if you make a payment for rent and the landlord doesn't declare a forfeiture, or it hasn't said in a notice to you, to the tenant that it's entitled to accept rent and still proceed with an eviction action, then usually the payment of rent and then the acceptance by the landlord of the rent constitutes or is deemed to be implied that the tenancy is still continuing on. So if you do make an effort like you've done to make a payment and you say this payment satisfies our obligation going forward and the landlord receives that, that definitely works in the tenant's favor. If there's an eviction action in the future and the landlord tries to say that you didn't make payments or you didn't abide by your obligations of the lease.
Great. A follow-up to that, and because some people are anonymous, or I'm curious if some people are in the same business, so please correct me if I'm making the wrong assumptions, but here's a follow-up. We are located in Oak Park and it is a family fun center. Our landlord is not willing to work with us and our rent is $48,000 a month. There is no way we will ever catch up. Is our only way out bankruptcy, or government will come up with some kind of plan for the amusement and entertainment industry?
Well, it's hard to know if your only way out is bankruptcy. It really, I mean, one of the things that needs to be done is maybe a bankruptcy attorney, someone that's qualified or understands the finances, and you work with your accountant and the bankruptcy attorney. You can make a determination on where your finances are at, and if it makes more sense to file for bankruptcy than not from a financial perspective. So it's really a financial analysis with your bankruptcy attorney, and you have to kind of just do a weighing process to see what makes more sense from a business perspective.
Great. And we're with you there. It's a tough time for everyone, so just know that you're not alone. We're here with you. Rachel, do you have that follow-up on the commercial tenancy emergency order?
I do. So LA County, it has different paybacks depending on how many employees you have. In LA County, it says commercial tenants with less than 10 employees will have up to 12 months post-emergency to pay back any rent. Commercial tenants with 10 to 100 employees have 6 months to repay, and landlords may not charge interest or late fees.
Great, thank you. And
then I also have the Ventura information.
Yes, ma'am, thank you.
So in order to, if you, under the state moratorium, which we're talking about Governor Newsom's orders that applies to commercial tenancies, there's no repayment time frame set forth in the actual orders. Ventura County, their ordinances have no timeline, but tenants are encouraged to make payments. So that's not very clear. And the city of Ventura says that repayment must be done within 6 months of the local emergency. And as we had discussed earlier, the city extended the local emergency to November 12 of 2020. So that would mean if you're in the city of Ventura, you have with 6 months of November 12, 2020 to pay back the rent.
Great, thank you. If the lease uses a security deposit, or I'm sorry, if the landlord uses security deposit for rent, does the tenant have to replenish the security deposit if lease otherwise requires the tenant to do so?
I can answer that. Generally, leases require that if the security deposit's used for rent or anything during the lease term, that the tenant does have to actually replenish the security deposit.
Great, thank you. Does Port Hueneme have a separate city ordinance for residential tenants?
I haven't seen one. Have you seen one, Rachel?
No, I haven't, and I don't see it listed on the, hold on, let me go to their website and see if I can find one.
Great. While you're
But I haven't seen one.
Great. While you're doing that, next question. Is there a reason why a landlord would not want to negotiate? My pool of tenants in the center I am located in, and they are all getting nowhere with the landlord, and the landlord would rather see us leave. Is there a financial or other reason that they would want that?
Mike, do you want to answer it? Or
Yeah, it's hard to know what the landlord is thinking. I mean, maybe they're thinking that this is a good time to to sell the property. Maybe they want to get out of the tenancy business. There could be a lot of issues. It's hard to know what the motivation is. Maybe they're banking on the future. It's difficult to know.
Great, thank you. When does the emergency order end? Is it whenever the governor lifts the emergency?
Rachel, how are you on that?
Well, that depends. So basically, if the governor lifts the emergency, at this point, it doesn't really matter because there's already the Tenant Relief Act in place, and then also the executive orders aren't extended past September 30th. But if you have a local or city government that has extended the local emergency, you'll have to look at that because Ventura recently extended the local emergency to November 12th. But that doesn't mean that maybe next month there's less and less COVID cases. So as we've seen with the Judicial Council, they can go ahead and revoke that. So, I mean, it's possible that it could be extended. It's possible that it could be ended early. So that's something that you'll have to, keep your ears out for, news articles and things regarding whether the local emergencies are being extended or they're being, terminated.
Great, thank you. When is back rent due in Santa Barbara?
Rachel, do you have the website up by any chance?
I do, I'm looking, hold on.
Okay.
And we have a follow-up regarding the prepaid October rent question. Can we now not pay rent until November, claiming the landlord accepted prepaid October rent and did not try to enforce September rent payment, and by omission accepted September deferral? Would that work?
Mike, do you want to take that?
I think it's always best to comply with the terms of the lease. And so I would encourage you not to create your own terms or to apply your own terms. It's just that in the event that the landlord brings an unlawful detainer action, the landlord's acceptance of the payment could constitute that the lease is still, it could be a defense that you would have in an unlawful detainer case, that the lease is actually still continuing and that you're not in default. But otherwise, I would encourage you, unless you have some sort of another deal, that you not imply that those conditions have been changed, but that you go ahead and try to comply with the lease if you can.
Great, thank you. So we've got just about 5 minutes left and 9 questions still. So my smart team of attorneys, are you able to hang on for a couple extra minutes, or should we just collect these questions and get them answered and out in email?
I think we could probably stay on for a few more minutes.
Thank you so much. All right, Rachel, you got that Santa Barbara back rent?
Hold on, almost.
Okay.
Okay, here we go. The deferred rents under the temporary eviction moratorium ordinance number 5941 that was issued on May 12 of 2020. That's for Santa Barbara. The deferred rents under this ordinance will be due and payable on June 1st of 2020 unless the council takes action to specify a different payback period.
Great.
This means property owners may begin eviction proceedings immediately if up to the 2 months deferred rent is not repaid in full at that time.
All right, thank you.
I hope that answers the question.
Yes, thank you.
Okay.
For Santa Barbara City commercial tenants, is there a policy by the city or county to prohibit late charges during COVID or late rent payments?
Rachel, you have that one, right?
Yeah, I'm trying to look at the order to see if it discusses that.
All right, well, Rachel is researching. Is there any new information regarding rent protection for nonprofit live theaters? It seems like we were the first to close and nothing that says when we can reopen, and our landlord is not interested in negotiating.
See, I've actually talked to a lot of nonprofits, and it came up at the meeting that I had with the assembly person. And there's nothing currently on the books or no legislation they're trying to pass to help it. But I do know that, you know, it's a real concern because nonprofits, the donations are down. They're all struggling right now.
Yeah. We have negotiated free rent abatements for current and or future periods with existing leases. Your thoughts on negotiating pulling forward with free abatements and apply against deferred rents during the COVID period and downturn?
Mike, do you want to handle that?
Well, why don't you go ahead, Doug, since you kind of spoke on that issue.
Okay, so can you repeat the question, Emily?
Yes. If we have negotiated free rent abatements for current and or future periods with existing leases, what are your thoughts on negotiating pulling forward the free abatements and applying them against deferred rents during the COVID period and downturn?
I would definitely bring that up negotiate that with the landlord, because you've already got the free rent in the lease for in the future. So if you can get the free rent in the future applied to what's currently back owed, it'd be a win for everybody.
I'm reading this as this might be the landlord.
Okay.
So Scott, if you could repost your question or put it in the chat.
If they're the landlord and they want to, it's actually, you know, I think it'd be beneficial because then you're dealing with the back rent and you're really not out anything that you wouldn't have been out, provided they stay in there and stay the rest of the term. So you would do a lease modification for it.
Great, thank you. If my residential tenant is not paying rent and I choose to sell the property in Port Hueneme, can I evict to make repairs, list, and sell the property?
Mike, do you want to handle this one?
Well, I think it's given the moratorium. I mean, if the tenant is not making payments, you're in a position now to provide notice that they're in default and to provide the tenant with the required excuses with respect to COVID. And so generally, you know, if they're not making payments, then you need to give them notice that they're not making payments and also provide them with the information about the COVID restrictions and exceptions. But then if you move forward and the time permits, then yes, I mean, you should consider bringing an eviction action if that's what's going to take to get the tenant to relinquish the possession of the property so you can re-rent.
The follow-up to that is that she was evicted prior to COVID, but then the moratorium put a stop to the eviction process. So it sounds like she was already evicted, then COVID happened, which stopped the process. Does that adjust your answer at all?
That's an interesting question. So, I mean, that means that a judgment is in place. There's already been a judgment of eviction, but she continues to rent there. I mean, she continues to reside there. It would be up to the tenant up to the landlord to enforce that or attempt to force that judgment. And I doubt the sheriff is going to do anything until the moratoriums are lifted. So even though the landlord may want to go through the eviction process, the sheriff isn't going to enforce an eviction until the moratoriums are lifted.
Great. He says there was no judgment giving, but the 60-day eviction notice was posted. So sounds like you're just kind of in a rough spot, and I'm really sorry about that. Rachel, you have my Santa Barbara City answer?
I do. So Santa Barbara ordinance number 5943 specifically states that the landlord's not allowed to charge late fees and interest on the late payments.
Thank you.
Mm-hmm.
The eviction moratorium extended to December 30th. Is this moratorium applied to the whole of California or just in Ventura County only? I have tenants in other counties.
Where's the December date? What the date of December?
It says the eviction moratorium extended to December 30th, 2020.
Well, there is the CDC moratorium that's for the entire United States, and that's good until December 31st of 2020. So if you're in an area that doesn't have a moratorium, then that would apply in your area if there isn't a local or county ordinance. But if this is a residential tenancy, the Tenant Relief Act is good until January 31st of 2021. Does that answer the question?
Let us know if it's residential or commercial. And could you speak for a moment about the hierarchy of the orders? Which can go before the other ones, or which will prevail when they're different? Can you speak to that?
That's a great question. So normally when you look at laws, you go from the state and the local, and then you also look at the federal. So here in California, we'd be looking at Governor Newsom's orders, and then you would look to what ends up happening is, the governor can make a broad order, and then the counties and the cities can also make an order that's more broad than what the governor has stated. So first you would look to the state, then you would look to the local, and then if there is no local law that governs, then you could look to the federal and say, hey, does this apply to me? Does that make sense?
Yes, thank you so much. A follow-up to that, I have 3 tenants who sent me a note saying that they are unable to pay rent in full because of COVID-19, but they provided no proof of lost income. Do I have the right to file the eviction on them if they don't pay full rent in October?
Is this a commercial or a residential tenant? And what county?
Why don't you post those answers either in the chat or in the Q&A, and we'll come back to that. This is a follow-up for the Port Hueneme eviction question. Is it accurate that the way things stand, which is a tenant in place where the eviction has been processed, but there isn't a judgment, is it true that he cannot sell his condo?
Mike, do you want to handle that?
Well, yeah, I don't know that it would prevent him. I mean, Doug, you may want to opine on this, but I don't know that it would prevent him from selling, but they're going to have an occupancy problem because the tenant it has a right to possession under the lease agreement, and that possession right continues even if there's been a transfer of ownership interest to a new owners. But without, so in other words, there has to be notice given to the tenant that there's a transfer to the new owner, and then the obligations under the lease for there to be an eviction. So it really requires, all the parties to work together. If the tenant hasn't received notice, then I think it's going to be difficult to enforce any sort of an eviction.
Yeah, Mike, if I can follow up, the evictions are basically for non-payment of rent, all the moratoriums. If the tenant is committing waste or there's some other grounds for evicting them, that doesn't, my understanding, correct me if I'm wrong, Rachel, the moratoriums don't prevent evicting a tenant for other reasons.
That's correct. That's correct, Doug. Yeah. So if they're, being a nuisance or selling drugs out of the house or, things like that, then yeah, it's only eviction relief for non-payment of rent due to COVID.
Great, thank you. It's very hard to amend a lease with new terms about deferred rent, payback plan, when the date of emergency order lift is not defined. What is your guidance on this? The landlord is being fair but firm with multiple commercial tenants.
I think it's a good idea just to work with the tenant about what those terms would be when it becomes clear what the date of the lift is going to be. So it's like we were saying in the presentation, it's always good to keep those lines of communication open. If you've got a tenant that you really want to work with, start trying to carve out those terms, and you can include it within the terms that, when the order is lifted, if it's within a reasonable period of time, and you can put a time restriction on that, what you consider to be reasonable, then these provisions will apply. So I would say open the door and start those negotiations now and carve out those terms. So when we do get some clearer definition, you'll have something in place.
Thank you. Okay, so we've got some follow-up information. So this is in regards to the 3 tenants who said they can't pay October rent in full, but they did not provide a loss of income. So these are residential tenants. They say they can't pay October in full, but they didn't provide proof.
If it's under the new Tenant Relief Act, the tenant just has to, the landlord actually has to serve a 15-day notice on the tenant. That also includes a notice from the state of California regarding the tenant's rights under the Tenant Relief Act. And the landlord also has to provide the tenant with a declaration of COVID-19 related financial distress. So this is where there's a weird twist, because the Tenant Relief Act does not require that your tenant provide proof of, documentation that they have lost income. They just have to provide the declaration. The documentation is only required under the new Tenant Relief Act if the tenant is making over $100,000 a year. So if you have tenants that aren't in that bracket of income, then they're not obligated to provide you with that documentation, but they do have to sign the declaration and return it to you.
Great, thank you. Just for clarification, with the extension of the emergency order to November 12th, does that keep tenants safe from eviction until then? And then it gives us 6 months to repay the past due rent.
I'm assuming this is the city of Ventura.
I'm assuming the same because it has that 6-month rent repayment time frame.
Yeah. So again, a lot of these ordinances actually have written in them what timelines they're tracking. So some of the ordinances will say that they're tracking the Governor Newsom's orders, and they will expire when the deadline expires on those, which is September 30th. Ventura has recently extended the local emergency deadline, and the Ventura City Ordinance says that it's good until the expiration of the local emergency. So there again, if the emergency's been extended for the city of Ventura, then yeah, they have 6 months after the expiration of the local emergency to pay the rent. And like we've been talking about, all these things are in flux. Ventura County and the city could, extend it to commercial. They could take back the date and say, oh no, the emergency's over in October. They could extend it. So you just got to, keep looking and see if that's taking place.
And just a moment, business owner to business owner and renter to renter, like this is just so hard and it's so stressful, and we all want to know what's happening so that we can make educated plans. So I just want to say again that you're not alone, and we're sorry you're going through this, and it's just really unimaginable. So just keep those chins up, guys. Follow up to you, Rachel. For Santa Barbara, you said June 2020. We're assuming you meant June 2021.
Oh geez, well, I already clicked out of the order.
Of course you did.
So I don't,
But I'm assuming if it was an order, it would expire next year, not this year. Keep researching. We'll keep it moving. Is there a website to review Orange County moratoriums on commercial tenants back to work timing so we can collect deferred rent? Is that going to be that website that we have to send out? All right, anonymous attendee. We're in the follow-up email, you'll receive a link that has all of the different moratoriums on it. Any suggestions for a landlord starting up a new residential during these COVID times? So I'm assuming residential rental during these COVID times.
Mike, you can chime in too, but I guess my big thing would be make sure you do a background check, credit check for your landlord and you're getting new tenants, and make sure that they have a job, because a lot of people have been laid off. You also may want to get personal guarantees possibly on the rent. Mike?
I think I would agree. I mean, I think it's kind of a good time to consider renting if you can, because you're going to get someone, hopefully this pandemic is going to come to, if you have a term that extends beyond 6 months or so, that could be a good thing, because then you've got a tenant in place, especially if the tenant has good credit. I'd encourage, generally, I think it'd be a good time for landlords to secure good tenants that need a place.
Great, thank you. Rachel, you done with your
I think
scrolling?
so. Basically, the County of Santa Barbara's moratorium says tenants will have up to 12 months following termination of the statewide emergency to pay back the rent due. Does that answer the question?
Anonymous attendee, let me know if that answers your question.
If not, if they want to just go on that link, all of the ordinances are all up there for the city and also the County of Santa Barbara, so they can feel free to click on it, look through. It's just hard because you have to really read through all of the ordinances in order to get the answer. So it's a little difficult to do in real time.
Great, thank you. So we have reached the end of our questions. So I'm gonna share with you just a little bit about EDC, which will give you a minute to pop more questions in that Q&A box if you have them. So I've said a few times, this is a really hard time for all of us, and you're not alone. And one of the ways that you're not alone is EDC, the Economic Development Collaborative. Your tax dollars have already funded consultants to work with you one-on-one. They're free to you. They are experts in their field. I am a client of EDC and I can speak to how well it works, and it is free to you. You do not have to do this alone. So I just want to say, hang in there. This is really hard and it's not over yet, but you're truly not alone. So with that, I want to thank all of our panelists. We really appreciate you. Their contact information is going to be in our thank you email that you'll all get. And we just really appreciate y'all being here. Have a good Thursday.